Thank you for joining us to another webinar. My name is Maria Madrid. I'm the Director of Latino Services at the Colorado Gerontological Society. Today I will cover with you how to complete your financial power of attorney, a step-by-step tutorial as part of our Advanced Care Planning webinar series. So a note before we begin, this webinar with the rest of our webinar series. We want to make sure that you understand that advanced care planning is more than just advanced directives. We believe that advanced care planning has a medical, a financial, and a legal component, so you are prepared in a comprehensive way. Um, all the information that I will be providing you today is Colorado specific. Some of the language is the same across other states. However, every state has their own rules and regulations on what advanced directives need to look like. So we want to be very conscientious of that. Also, the Society provides assistance to complete your advanced directives. So if you need assistance, we do provide that assistance at no cost to you. Also, you could find the form that we're talking about today, which I will make available after this webinar as it's being recorded. I will make the slides, the form, in addition to the recording available to everyone in attendance. You could also find them on our website, which is senioranswers.org. And even though the Society focuses on older adults, we do promote advanced care planning for everyone over the age of 18. And you say why 18 is because when we turn 18 under the law, we're adults and we're independent from our parents. So we want to make sure that everyone over the age of 18 is considering advanced care planning. And before we move forward, feel free to ask any questions in the Q&A or in the chat. I will check that as I go along. So my objectives for you today is for you to walk away learning how to complete the form, understanding what information is needed, best practices to follow, and who to give copies to once your form is completed. So let's specifically define what the financial power of attorney does. The financial power of attorney, once again, this form is only for Colorado. Every state has their own. But the financial power of attorney, it's a legal document. It outlines who is going to speak for you. This is your agent on your behalf in regards to your financial matters. So money, property. You need to be at least 18 years and older in order to be able to complete this form and have decisional capacity. What is decisional capacity? It's the ability to provide informed consent or refusal to anything, whether it's medical treatment, whether it's finances. And note that the financial power of attorney, it's only for finances. In previous webinars, we have covered the medical financial power of attorney, and that's only for the medical durable power of attorney, it's only for medical matters. Okay, so that's why we have a medical financial power of attorney and why we have a medical and a financial, because the financial covers finances, the medical covers medical. So with this regard, very important here, if a person no longer has decisional capacity, whether because it's a disability, a diagnosis that they're no longer able to do this, then a advanced directive, a financial power of attorney is not, it shouldn't be completed by that person. So let's go into what information do you need. So let's talk about let's talk about your agent and alternates. So this is the same language that we used in the medical uh, power of attorney. So this is helpful, right? Because we're getting used to the terms. So the agent is going to be the person that is going to speak on your behalf regarding finances. Your alternates, they can step in the event that your primary agent is not able to speak on your behalf for whatever reason. So think about it as having a plan A, B, and C. So your primary agent is your main person. If they're in the same situation as you are or something else happens, then your alternate number one could step in. And if both your agent and alternate number one are in the same situation, then you have alternate number two. Now, I understand that not everyone has three individuals. If that is your case, that's completely fine. But make sure that whoever you're considering, you at minimum need the agent to be able to complete this form. If you have alternates, that's great. But note that whoever you're considering as your agent or alternate, they need to be at least 18 years of age or older. You need to talk to them before completing this form and make sure that they're willing to accept the responsibility. In a little bit here, I'll go over the agent's responsibilities. So we want to make sure that they're up to the task. Also, we want to make sure that whoever we're choosing for our agent or our alternates, that they're available in case of an emergency or if you're going to need ongoing care and support in this area. Also, a lot of people think that their agent and alternates can only be family or blood related. That is not the case. It could be anyone of trust. So it could be a neighbor, it could be a friend, it could be a chosen family, not necessarily blood family. So it's basically people that you trust that are 18 years and over and that are willing to accept the responsibility in addition to being available. So make sure that before you complete any document, you are having these conversations. So the person has the ability to say, yes, I'm willing to accept this responsibility, because we don't want you to be in the situation where you need this type of support and you didn't talk to your agent and your agent gets that call and they are not able to speak on your behalf. They're not willing to take on that responsibility. And at that time, your financial power of attorney is null and void. So we want to make sure you have individuals that are willing to accept that responsibility. So before completing the form, let's focus on some best practices, recommendations, and the information that you will need. So the first thing, like I previously stated, make sure you talk to your agent and alternates. Make sure that they understand what you're asking of them. If they are not willing to take the responsibility, please note that it is a responsibility. It's basically agreeing to anything financial for that person that um, they would be monitoring that. So it's a rather large responsibility. So we want to make sure that the individual fully understands and has the opportunity to say yes or no. Next, the financial power of attorney needs to be notarized. So you will need two witnesses and they need to be 18 years and older. Um, and the witnesses could not be your agent or alternates. Okay, it could be anyone else except your agent and alternates. Also, before completing the form, I highly recommend that that you gather all the information that you need, so that way when you're completing the form, you could just enter the information. So what information do you need? You need your information, so your name, your address, those things. In addition to that, you will need your agent and alternates information, so their full name, their full address, and their main phone number. And just another note that is very important, and this makes it a little bit difficult and complicated when we're talking about planning, because unfortunately at the same time, and I'll tell you why, banks have their own financial power of attorney. So the form that I'm completing today with you, that form you could use for almost all credit unions. But if you have a major bank like US Bank, Wells Fargo, Chase, those banks have their own financial power of attorney. So make sure you check in with your bank to see what their process is. Some banks have you complete one financial power of attorney per account. So if you have a savings and checkings account, you're going to have two financial powers of attorney with that bank alone, but you would need the one that we're talking about today for a lot of other things, and we'll go through those in a little bit. Other banks are okay with just having one of their financial power of attorney forms to cover all the accounts that you have with them. So please note that that is an additional step that you need to take to ensure you're completing the right form and you're following your bank's policies and procedures for them to accept your financial power of attorney. So, yes, that makes it a little bit complicated, but here's the positive. Because there's so many issues with financial exploitation, banks have taken the additional step to make sure that if a financial power of attorney is completed on any of their bank accounts, that is actually what you want to do. So that is the positive in that regards. The other thing that I would like to touch on before we continue with this conversation, it's the importance of how we have our bank accounts set up. A lot of individuals just go ahead and add that person onto their bank account. I don't recommend that. Why? Because when we add someone else onto our bank account, they become co owners. So if that is our spouse who we're adding onto that bank account, that's completely fine because it's our spouse. But if it's anyone else, and for whatever reason they have to file bankruptcy, that bank account becomes part of their assets and they would have to report on it, even though they maybe had nothing to do with the amount of money associated in that bank account because they're listed as a co-owner. Now that's exactly what they are viewed as when it comes to any financial reporting. So just be conscientious of that, because I know a lot of folks just think it's easier to go ahead and add someone onto your bank account. We want to make sure that when we're setting up our plans, we really have things set up in a way with your finances and their finances are separate and they're still able to support you in the way that you need, instead of meshing your finances and their finances. So we want to make sure that you still get the support that you need, but it's not compromising your finances. So I do have a question about credit cards. So yes, you do want to check with your bank. Um, and see what that process is for your credit card. So any account that you have with the bank, whether it's checkings, savings, a CD, an IRA, all of those. So any accounts that you have under any financial institution, you want to make sure, whether it's a credit card, whether it's a savings, all of those we want to check with those banks, whether it's one bank or if you bank at multiple banks, make sure you check with all of those, okay? Um, All right, so let's go ahead and continue to move forward. So, the financial power of attorney, it's also known as the general power of attorney. So, you will see that throughout the form in some areas. So, the form that we're completing today is a fillable form provided by the Colorado Bar Association, and it could be found in the Colorado Senior Law Book. When you receive the PowerPoint, everything in orange, you could link to it. So you will have access to the handbook, which I highly recommend. They publish a handbook every year, so that's a nice um, resource to have. Once again, let's cover who's the agent. The agent is the person that would make decisions on your behalf, and the person that is completing the financial power of attorney, they are the principal. So you will see principal throughout the form. So we want to make sure that you understand that you are the principal, and the person that you're giving authorization to speak on your behalf, they're the agent. Okay. This form, since it's a fill in the blank form, it allows you to designate one agent as your primary agent. But the instructions do say that if you want co-agents, that you could include this in the special instructions, which we will cover that piece. But just note that anytime that you have two individuals, that when you choose co-agents, you need to make sure that those two individuals work together well. Why? Because they're going to have to do a lot of teamwork trying to provide the support that you need. Some individuals have the same person doing their financial power of attorney and their medical power of attorney. Some individuals have two different individuals, so they'll have daughter one to do the finances, and they'll have daughter two to do the medical piece. So there's no right or wrong. Just make sure that as you're considering who's going to be the individual or the individuals that support you, that there are areas that they feel comfortable with the responsibility, that they understand, and that they're able to work together. Because if your medical needs, there's a financial piece to it. Those two individuals, the medical durable power of attorney agent and the financial power of attorney agent, they're going to have to talk to each other. So keep that in mind. Also, like I said before, if you do not talk to the individual or individuals that you're thinking about as far as an agent and alternates, note this here. If your agent is unable or unwilling to act for you, your power of attorney will end unless you have alternates. Okay, so this is why it's so important to talk to folks before we put their name down on the form, because we want to make sure that we are fully protected and that they're willing to take on that responsibility. Okay, so whoever you're thinking as far as your agent and your alternates, please have conversations with them. Okay, because we want to make sure that they are willing to speak on your behalf and provide you with the support that you have outlined for them. So one of the questions, do co-agents have to agree on all actions? And that would be a yes, because since both of them um, are co-agents, that means they have to agree on the steps to take. They're going to have to ensure that the responsibilities and duties of the agent, they also understand those and that they're keeping track of those. So it's much more difficult to have co-agents instead of a primary and then alternates, because then you have one person responsible for everything, and then you have the alternates that would step um, in case that the primary is not able for whatever reason. So typically it's easier to have the primary instead of the co-agents, because the co-agents need to agree, need to be able to work together. And if they don't do that, then it's going to be much more difficult to provide the support that you need in the way that you want it. Also, the form that we're covering today is a 6-page document. So make sure that whether you're completing it on your computer or if you're going to print it out, that you print out the full 6 pages. The document itself needs to be the full 6 pages, and the form needs to be notarized. And you will need the 2 witnesses to get it notarized. So let's talk a little bit about agents' duties, because I think a lot of folks don't really understand what the agent's duties are. And these are specifically taken out of the form. So the agent duties are in page 5 of 6 and 6 of 6. So the agent needs to basically follow what the principal, you, expect in regards to property, in regards to money, and what is in your best interest. They need to act in good faith. They shouldn't go beyond the authority that you have given them in the power of attorney. This is why it's so important to consider all the different scenarios and how you might need assistance to make sure that you complete a comprehensive financial power of attorney. When they're doing anything on your behalf, they need to identify themselves as your agent. And here is an example of how they would sign on your behalf. So it would be your name by their name as your agent. And also, they do need to act with loyalty to you as the principal. This means that they're not going to sell your house and now they have a brand new house for themselves and a brand new car. So they cannot use your finances to enhance their assets. Also, they do need to act with care, competence, and diligence. So we want individuals that are responsible, that we trust, so they're able to do these steps. Number 4 is one that is very important. They need to keep track of all the finances, right? Any receipts, any payments, any type of transactions that were made on the behalf of the principal, so on your behalf. Also, here's number 5 that we've talked about before. They need to get along with whoever is your agent under your medical durable power of attorney, okay? Because those two things will eventually overlap, those two areas. So we want to make sure that whoever you select, especially if it's 2 individuals, that they could work together. And also, number 6, the agent needs to attempt to preserve the principal's estate plan if you know the plan and preserving the plan is consistent with the principal's best interest. So once again, they need to understand what your plans are, what you need, and how to manage all of that to make sure that that is followed in the best way possible. So this is why I like covering the duties, because that way when you have the conversation and you have the form, and this makes this form very user friendly, those agent duties are right there for you and your agent to see, and there's no confusion on what the expectations are. So here we have a question about what is the difference between a POD and FPOA. So POD is a payable on death, And that is very different than a financial power of attorney. A financial power of attorney, you're giving someone the ability to speak on your behalf for your financial matters. Payable on death, or POD, it's something that you could set up on your bank accounts. When you pass away, whatever's left as far as a balance on an account, you name a beneficiary, and that balance goes to that beneficiary. So that is payable on death. That is another thing that I do recommend for people to consider, because that makes the process much simpler when the person passes away. So that is another requirement. Okay. So I do have another question. So, what reporting requirements are mandated by law for the financial agents? So, all six of these things that we've covered under the law, those are the things that the agent needs to do. Breaking any of those six duties can result in criminal action, in being considered exploiting the individual, or anything like that. So all those six things are things that under the law, it's expected. So let's talk about when the agent no longer has authority. So the first one is if you pass away. So this is why there's the different spheres, the medical, the financial, and the legal. And the legal is where we talk about basically what happens when the person passes away, right? So what you're doing now, the financial power of attorney, the medical durable power of attorney, those are for when we are alive. When we pass away, the financial power of attorneys, those become null and void. So those documents die along with us. That's one. Two, you could change your mind at any time who your agent is, so you could revoke the power at any time. There's also power of attorneys could be very specific. So it could be for something as simple as I just need this person to help me do this one thing, like selling a home. And as soon as that home is sold, then that power of attorney is no longer valid. Or if there's a particular purpose that you have in place in your power of attorney and that's accomplished, then that power of attorney is terminated. The other thing that you do have to consider that it's the same for the medical durable power of attorney. If you have your spouse named as your agent and you divorce them, as soon as you divorce them, that power of attorney becomes null and void, unless you have put in the special instructions that you would still like for them to continue to be your agent even after that divorce decree is set up. So make sure that if you do at any point in time, if you do get divorced and you had your spouse listed as your agent, you either have to complete a new one after the divorce decree, to go ahead and name a new agent, or name your ex-spouse. Okay, so now let's go into how to actually complete the form. So for this part, I am going to turn off my camera so you could see the whole entire screen, because I've taken the different sections in the form and made them large, so that way you could see where specifically I am in the form. And that way this is of more use to you. So at the bottom of the screen here, just so you know where I'm at every step of the way, it'll tell you page 1 of 6 or page 2 of 6. So just keep that in mind, because I am blowing up different sections of the form for you to see specifically how to complete the form. So whether you're completing the form on your computer or you're handwriting it, the information is going to go in the same place. However, note that if you are handwriting, we want to make sure that you are using black or blue ink pen. Never use pencil, and also make sure that everything is legible. Okay, because we want to make sure that there's no questions about, does she mean, is it John or is it Joy? What is the name? I can't tell if it's John Doe or Joy, or Joyce. So make sure that it's legible. So let's begin with the very first thing that you need to do on page 1. We're going to use the example of Jane Doe. She's been our example throughout the whole webinar series, so we'll continue to use Jane Doe. So Jane Doe is the principal. Remember, the principal is you, so throughout you will be highlighted in green. Your agent will be highlighted in this light blue. So Jane Doe, the principal, has decided to name her agent John Doe. So here we have the name of the agent. It's the full name. We have the agent's address, and note that the address is fully listed on there. So we have the house number, we have the name of the street, we have that it's a street, we have the city, the state, and the zip code. We also have the agent's phone number. And note here that we have the area code. We want to make sure that anytime we note a phone number or any contact information, that it's the first, the full phone number. Okay. It's no longer the case that everybody has the same area code. So we want to make sure that we make it as easy as possible for that individual that is going to assist you to be contacted, notified. So we want to make sure that we use a whole phone number. All right, so let's go to the next page, and this is going to be page 2 of 6. So page 1 of 6, we have wrote your name, and we've said who your primary agent is. For those of you that are going to list alternate agents, we're going to use that in page 2 of 6. So this is where they will go. Designation of successor agents. This is optional. So if you have your alternates, this is where you're going to name them. Jane Doe has selected her first alternate to be Jim Doe. So alternate successor number 1, we have his full address, 1129 Pennsylvania Street, Denver, Colorado, 80203. We have his full phone number. We have that area code and that phone number. Jane has also selected Mary Doe as an alternate. And we have Mary Doe's full name, where the second successor agent name goes. Then we have her full address and her full phone number. So your alternates are going to be in page 2 of 6. I have a question here. Can the principal limit or expand duties of the financial agent? So this form is not going to allow for that. That would be something that under advisory of an attorney, that might be the case. This form is fill in the blank. So this form would not allow for something like that to take place. So on page 2 of 6, this is where you indicate what powers you're giving your agent. The powers are the different areas where you're giving your agent authorization or permission to help you. So it could be everything from real property, so real estate, your tangible personal property, stocks and bonds, commodities and options, banks and other financial institutions. If you have a business, so operation of an entity or business, insurance and annuities. If you have a state trust and other financial interests, claims and litigations, personal and family maintenance, benefits from governmental programs or civil or military service, retirement plans, taxes. So some individuals use the all preceding subjects to go ahead and give permission in all of these areas. And where I've seen it, the individual basically says, I don't know what areas I might need assistance. So I want to make sure that they have the ability to assist me in all of those areas. Other individuals, if they don't have certain things like a business, then they go and put their initials on each. And if they don't have a business, then they don't include that. So this is where you get to tailor it according to what type of supports you want from your agent. Okay. The one that I do highly recommend for everyone to consider including is benefits from governmental programs or civil or military services. So if you need to go into a nursing home or assisted living, and there's all the financial questions that come into that, whether you're able to pay or not, or if you need to spend down, there's a lot of steps to go through. But if you have someone supporting you in that area, they would be able to apply for Medicaid and other state governmental programs to help you through that process. So that's a great one to have to ensure that whatever the situation is, and if your level of care increases where you do need assistance from governmental programs, that is included. In the banks and financial institutions, once again, make sure you check in with your individual bank, but there's other financial institutions such as credit unions. So just make sure that whatever financial institutions you do business with, that you're checking with them to make sure that this form will suffice. So next, there's some other, and this is part of page 2 and 3. There's other optional authorizations that you could go ahead and give your agent. So this could be everything from changing or terminating everything from trusts, rights of survivorship, changing the beneficiary designation on accounts, um, authorizing another person to have the same authority you gave your agent, annuities take over your fiduciary powers in business. So, fiduciary powers, any person that is an agent, um, that is listed as an agent in a financial power of attorney. Fiduciary powers means that you are going to act in the best interest of that person. So if you are a financial power of attorney for someone, this is an area where you could have your agent assist in that area while you're not able to. So that's another important area. So make sure that when you are looking at what this document needs to look like for you, that you are going down a checklist and you start listing, okay, these are the things that I have, these are the things that I would need assistance in, how do I want that to look, so that way you could go ahead and complete this form in the way that makes sense to you. And once again, in order to say I give someone authorization, my agent, you would need to put your initials in each area that you want to give permission to. Okay. All right. So let's continue on page 3 of 6. And this is where we get into the special instructions area. And this area is used for two things. So the effective date, unless you say something different in the special instructions, this financial power of attorney is going to start automatically. It's going to be effective immediately as soon as it's signed and notarized. So if you want this power of attorney to be effective when you're not able to communicate, then you could go ahead and state that in the special instructions. You could use some of the example language that I put down here. So you could say this power of attorney is effective when I become incapacitated and cannot communicate my needs. So it's a very specific time where either based on a medical crisis or something else, you wouldn't be able to communicate your needs. And at that point, they are able to step in. The other area that we've talked about is if you want co-agents. Um, so with the co-agents, they're not required to act together unless you include that requirement here, but they do have to agree. So I know that's a little bit confusing, but basically they have to be on the same page because we are talking about property, we're talking about money, so they do need to agree. They don't need um, um, to be present every single action, but they do need to be able to check in with each other, to follow up on things together, and make sure that the plan and the way that you have things set up is the way that things are going through and that they're checking in. So make sure that if you do want co-agents, that you are specific, and once again, make sure it's legible, make sure it's understandable, because sometimes we write things in a way that completely makes sense to us, but that might not make sense to someone else if they're looking at this without knowing you and what you might have meant. So I would say be very clear and very specific. And as far as the effective date, just make sure that you're able to know what you want that to be, so you're able to have that start at the time that it makes sense for you. Um, so can the effective date of financial power of attorney be when you are declared to be incompetent? So um, yes, you could go ahead and document that, but who would you want to name you incompetent would be the question. So when we say, when I am unable to communicate my needs, um, as soon as you can't communicate your needs, that person could step in. But when we're talking about someone declaring you incompetent, um, are you saying medical staff, and what kind of medical staff would you want? So if you want something tailored to that degree, I would recommend for you to talk to an attorney, so you could put what those limitations are. Who's going to declare you incompetent, and under what circumstances, and who would be that acceptable person? Is it your primary physician? Is it any medical personnel? Who is that person? So we want to make sure that you're not creating barriers in your own financial power of attorney. So just make sure that if that is the type of very specific starting point that you want, that you maybe seek some legal advice to make sure that you don't make it so where there's no way of executing those special instructions. So your agent could actually be able to step in. And if you're really that concerned about that person supporting you, where you want to make sure that you are declared incompetent first, then consider, is that the person that you want to assist you? Because we want to make sure that we're selecting people that we trust. So if there's a concern that maybe that person is not going to act on your best behalf, maybe that is not the person that you should consider as your agent. But if you want that effective date to be that prescriptive to that level, I would recommend for you to talk to an attorney and getting a tailored power of attorney with that type of language. So here we have a question about how does the financial power of attorney agent relate to conservators? Does having this form prevent rogue assistance of a conservator? So great question, Michelle. Thank you very much. So a financial power of attorney is completed when we have the cognitive processing abilities to give permission or to refuse things, right? So this has to happen before we become incapacitated, or there's a medical crisis or some other issue where we're not able to give permission for this person to speak on our behalf. That's the first thing about the financial power of attorney. When we haven't completed our financial power of attorney and something happens, and we need someone to manage our finances, at that point, the only way that our loved ones or someone else can assist us is going through probate court and becoming our conservator. And requesting conservatorship is a lengthy process. There is an emergency process, but still we're talking about weeks could go by before you get a hearing. There is an extensive number of forms that you have to complete in addition to paying filing fees. So a conservator is only assigned by a court, and it has to be proven why you're requesting to be a conservator. So if you plan ahead of time, and you have a financial power of attorney to help you through different stages of life, then you most likely you won't need a conservator. A conservator comes in when we haven't done our planning ahead of time, and now we're in a situation where we can't give permission for that person to help us. So the only recourse is requesting to become a conservator through the court. That's the only way that our loved ones would be able to help us at that time. So, so if you have a financial power of attorney, that is going to help you not having to go through the conservatorship process. I could tell you that with the families that I have helped request conservatorship, there is an entire process where the court sends out a visitor to see what the situation is. A physician does need to sign a letter indicating why you're not able to manage your finances. So it's not just I'm submitting a form that I created myself and now I'm a conservator. A conservator could only be named by the probate court. And this is a very serious request when you request to be a conservator, because basically the court is taking away someone's right to make their own financial decisions. I hope that answers your question. If not, go ahead um, and let me know. Um, and I do have a question of do government benefits include Social Security? So Social Security is one of the governmental benefits, but they have their own system. So If you want assistance managing your Social Security benefit, there's advanced designation, and I would recommend for you to complete that piece. Um, Check out our YouTube channel for financial advanced directives. That's where I go into detail about what a representative payee is in advanced designation. So we have another question about special instructions, and it reads, should it address coordination with medical agents' decisions to spend money? So if you want to get that prescriptive, once again, I would say seek legal advice from an attorney, because you do not want to create barriers within your advance directives. The more prescriptive you are, the more barriers you put for your team. So if you have, and this is why I say that people have it set up differently. When you have the same person doing the finances and the medical, that person is already, they already know what's going on, right? But if you're going to have two different people, then part of what I recommend in order for you to not create barriers within your documents is to have those individuals talk about, if this is to happen to me, this is how I want the two of you to work. So the two of you would have to check in to talk about what's happening with the medical and finances, to make sure that you coordinate and you understand what's going on and how finances in medical is impacting each other. So that's what I would recommend about that level of uh, detail in the special instructions. I do have another question. Is a conservator the same as a court-appointed guide? Excuse me. Is a conservator the same as a court-appointed guardian? So, Michelle, make sure that you come to our webinar on Friday, because we're specifically covering legal guardianship and conservatorship. Okay, because what you, I think your questions are very valid. And what the financial power of attorney does is to ensure that you have a plan in place before you need it. The legal guardianship and the conservatorship are two different things. Both of them are through the court. The guardianship only handles medical, the conservatorship only covers finances, and those need to be processed through the court system to become a conservator or a guardian. And that is for individuals that have not completed their financial power of attorneys ahead of time, that do not have a plan set in place, or that they have a cognitive or developmental intellectual disability that prevents them from uh, giving permission for someone to assist them in this way. Okay, so let's go to page 4 of 6. So 4 of 6, and please note that this area is completely optional. Nomination of conservatorship or guardian. This does not mean that you have given someone the authority to become your conservator or guardian. A person cannot do that. Only the court system can appoint a conservator and a guardian. Conservator takes care of finances, a guardian takes care of the medical piece. And how is this different from the power of attorney? If you become completely permanently incapacitated, the way that you completed your financial power of attorney does not cover all the different areas that you need assistance, but now you're in a place for whatever reason, medical crisis, medical diagnosis, whatever happens, that you're not able to give permission for that person to help you with the other things that were not listed in the financial power of attorney, then at that point, your loved ones might have to seek conservatorship or guardianship, because now we have to talk to the court and make that request, because you yourself cannot speak or give that authorization. So in this area, you're just saying, if that becomes the case for me, this is who I'm nominating. This is who I would want to be my conservator. This is who I would want to be my guardian. Okay. And remember, you're just nominating, you're not appointing. Here you would say who the person is. The first one is for conservator. You would put their full address and full phone number. You could have the same person for a conservator or guardian, or you could have two different persons. So if you have a different person, you would put their full name here, full address, and full phone number. Once again, this is completely optional. And this does not mean that you have given someone the authority to be your conservator or your guardian. This is just you saying, in the event that I need a conservator or I need a guardian, this is who I would like to be considered. Because only a judge in a court of law is able to appoint a conservator or a guardian. So now in page 4 of 6, this is where you will need to sign. Please don't sign this document until you're in front of a notary. The notary will need to make sure that you provide proof of identity. So you will need your ID or driver's license. You could also use a passport or any other approved um, proof of identity. So here, Jane Doe is going to sign in the first line. She's going to have to print her name on the second, enter her full address and phone number, and date it. Okay, but once again, this is in front of the notary. In page 5 of 6, this is where the notary needs to complete the section. So they will say what county, they will say on what day, by whom. They will also include when the commission expires. So one of the questions that I get asked often is, what happens to my document if the notary's commission expires, but I still want my document to be valid? So the notary's commission expiration date is there to note that when this document was created, the notary's commission was valid and it wasn't expired. If it was expired, then he wouldn't or she wouldn't be able to notarize this document for you. The notary's commission expiration date does not invalidate at all your document. So, even when that notary's commission expires, your document is still valid. So you do not have to take additional steps. The only time where you would have to redo the document is if you change your mind about any of the powers that you gave your agent. If you want to change who your agent is, at that point you complete a new form. But that commission expiration date does not negatively impact your document in any way. Just make sure that when it is completed, that the commission date has not expired, is up to date, and your document is good. The notary will sign the form and they will say who completed the form. So if you completed the form yourself, then it would be you. In this case is Jane Doe, and they will include their notary seal. I see that I have some more questions coming in, so let me go ahead and address those. Um, so I do have a question about, is a durable power of attorney and statutory power of attorney the same thing as a financial power of attorney? So there's different powers of attorney, and depending on the purpose of the power of attorney, it's going to have different names. So what we're talking about today is a financial power of attorney. There is durable power of attorneys and there's statutory power of attorneys. The one that we're covering today is a financial power of attorney. So if you have additional questions about durable power of attorneys or statutory, I would recommend for you to seek legal guardianship if you have questions of which one would be best for you or how you're attempting to use that on yourself. I have another question. If you do a new form, what happens to the previous one? Does it automatically become void? So, one of the things that you want to do is once your form is completed, you do want to give copies to the appropriate parties. We'll cover that in a second. Um, so, we do want to make sure that if we change a power of attorney, that we are communicating with the individual. You're no longer my power of attorney. I have changed this, and let them know, and ask them to provide you with the previous copy that you gave them, to go ahead and destroy that copy, as well as any financial institutions that you provide them with the most up-to-date copy, because the financial institutions will look at the one that was dated last, and that's the one that they will use. So now that you've completed your financial power of attorney, what do, oh, excuse me, I went far ahead. Okay, so now that you've completed your financial power of attorney, let's talk about who you give copies to. So you always want to make sure that you keep the original advanced directives in a safe place. So make sure you always keep those in a safe place and give your agent, alternate, and financial institutions a copy. So that way everybody is on the same page what the powers are, who's doing what and when. So your financial power of attorneys should not be a one-time thing and now I never check them again. No, you should be reviewing all of your advanced directives at least annually to make sure that it's the plan that you want, that it's reflecting your needs. If there's any change in medical conditions and your financial conditions, if you get a new diagnosis, if you get married, divorced, specifically divorced, because your power of attorney will become voided if your ex-spouse is your agent. Or if you change your mind about any of the powers or who is your agent or alternates, those are all times when you should be reviewing, and if you need to make changes at that point, make changes in your advanced directives. So note that this is only one of the financial pieces. We've gone through the medical pieces, and the next two webinars on legal guardianship and conservatorship and the last will and testament will cover the legal aspects. And I want you to have resources. So once you get access to this PowerPoint, all these links are hyperlinked, so you could go to them. Make sure you do. There's great information there. In front of you, you will see my contact information. I have gone 3 minutes over. Thank you for sticking with me. I will make this recording PowerPoint and financial power of attorney available to you. And the questions that I did not address on the on this presentation, I will make sure to include on the email. So look out for those. Thank you so much. Be well and have a wonderful day.